So, what happens when you sue your employer? Well, in this video, I'm going to break down every step of the lawsuit process, from hiring a lawyer to filing the lawsuit, all the way up to trial. So stick around to find out more. Nothing in this video is legal advice. Talk to a lawyer about your specific situation to get legal advice. Okay, let's start. So, before we talk about the lawsuit process, we first need to answer this question. Can you even sue your employer in the first place? I talk to people every day who want to sue their employers, but they don't have any legal basis to do it. You see, in order to be able to bring a lawsuit against your employer has to actually break the law first. And employers can do all sorts of really unfair and crummy things without actually breaking the law. So the first step in this process is to determine whether or not your employer actually broke the law. Some examples would include terminating an employee because of their protected characteristics, like their race, gender, age, religion, or disability status, just to name a few. Or terminating an employee who made a complaint about discrimination or harassment on the basis of those protected characteristics. Or terminating an employee in retaliation for taking pregnancy or medical leave. Those are just a few of the illegal employment practices that employers sometimes engage in. And I've made videos about all of these illegal employment practices, so check out the rest of my videos on my channel to learn more. I also wrote detailed guides on my website about the different illegal employment practices, so I'll put a link to my website in the description of this video as well. Okay, so now that that's out of the way, you have a viable legal claim. Your next step is to hire a lawyer. So let's quickly talk about the process of hiring a lawyer and what that looks like. You'll need to call or email employment lawyers who represent employees, not the ones who represent employers. And the first person you'll talk to will probably be an intake person. You'll give that person a brief overview of the facts, and if you have a viable legal claim, you'll probably get a call back from a lawyer or a paralegal. And the kind of lawyers that represent employees generally work on a contingency basis. That means that they only get paid from what they recover for you. If they don't recover anything, they don't get paid. So they usually only take good cases. Watch my video on what makes a good employment case to learn more about that. I'll put a link to that video in the description and in the card up here. Now, don't get discouraged if a few lawyers pass up on your case. Sometimes lawyers are genuinely busy and unable to take on new cases. It happens to me all the time. But if you talk to 10 lawyers and none of them want to take your case, there's probably something wrong with your case. Okay, so now you have a case and a lawyer has taken on your case. The next step in the process is the investigation of your case. This is where the lawyer that you hired will go through the facts of your case with a fine-tooth comb. The lawyer will ask for any documents or notes that you have, and I usually ask for a timeline at this point too, which is a detailed chronological summary of everything that's happened. Then, you and the lawyer will probably have a few long conversations and email discussions about everything that happened to you. Once your lawyer is done investigating, the next step in the process is to start drafting. The next step is usually to send a demand letter. And I say usually because demand letters aren't necessary in every case, but they can be really helpful in a lot of cases. And a demand letter is basically just a letter that a lawyer will send out before filing the lawsuit as an opportunity to settle early on, before anyone has incurred any costs. The demand letter will spell out for the defendant exactly how they broke the law and the legal liability they face because of their violation. And the demand letter will end with a settlement offer, which is a way of saying to the defendant that if you pay this amount of money, we'll drop the lawsuit. And generally, in response, defendants will make some offer to settle, but it will be much lower than the demand. And the parties can go back and forth negotiating the settlement amount. Sometimes the defendant will make an offer that the employee will accept, but more often than not, the defendant's offers will be insufficient. So we end up just filing the lawsuit. But the value of the demand letter process, in my opinion, is learning about the employer's defenses. Because if the employer has some really strong defense, or something that just completely defeats your claim, the defendant is going to let you know that as soon as they get that demand. So the demand letter process is a great way of seeing whether or not there are any giant landmines that we are about to step on. The next step is initiating the lawsuit. And to do this, your lawyer will draft a summons and complaint and serve it on the defendant. The complaint is a legal document that looks a lot like the demand letter. It spells out exactly what the defendant did to you and how its conduct violated the law. The summons is a legal document that basically says to the defendant that it's being sued, and it will need to answer this complaint and show up in court. And once the defendant is served with a summons and complaint, your lawyer will then go to the courthouse and file these documents with the court, along with proof of service. And once that's done, your lawsuit is initiated and the defendant has about a month to answer the complaint. But their answer to this complaint is just the beginning of the litigation process. The The next phase of the litigation process is called early motions. And I should first tell you what motions are. Motions are just a way of asking the court to do something. And the early motions usually consist of the defendant employer asking the court to do something. And the thing that they ask the court to do early on is to either dismiss the case or move it to a different venue. You'll have nothing to do with this process, it will just be legal arguments. The defendant may argue that the complaint is defective or that the court doesn't have jurisdiction, and sometimes they win these arguments, but more often than not, they lose. And either way, these early motions usually don't tank your case. If your complaint is defective in some way, your lawyer can usually fix that. And if the case is in the wrong venue, you'll just need to switch to a different venue. Mainly, these early motions are just a pain in the neck for your lawyer. The next phase of the litigation process is called discovery. And this is really the bulk of the litigation process, especially for you because this is where you'll have to do a lot of the work. Discovery is where both sides have to exchange information. They get to discover all the facts. And discovery is really helpful for us because we can get so much information from the other side. But it's also a huge burden because the other side will do the same to us. And the information that they will be asking for might be stuff that you don't want to share, but a lot of the time you'll have to. Discovery consists of written discovery and depositions. Written discovery is written questions and requests to produce documents. The written questions will be things like name every employer you've worked for the past 10 years, or admit that you had a performance review in June of last year, things like that. And the requests to produce documents will include requests for text messages, emails, tax returns, medical records, or job applications, just to name a few. And depositions are when you get interrogated by lawyers on the other side. And I know that sounds really scary to be interrogated by a lawyer, but if you have a good lawyer yourself, your lawyer will have prepped you extensively for that deposition. So there will be nothing to be scared about, and your lawyer will be there with you the whole time. The next phase of this process is dealing with even more motions. But one really important motion happens at this point, right after discovery, and it's called summary judgment. Basically, a summary judgment motion is when either party says to the judge that, look, we just did discovery, we have a bunch of facts and evidence that everyone agrees on, so you, judge, can make a final decision on everything and end it all here without having to go to trial. And in most employment cases, the defendant employer will bring one of these motions for summary judgment, and your lawyer might bring one too. At my firm, we like to stay on offense, so we usually bring one of these motions too. These motions are a lot of work, so during this process, just be as responsive as possible to your lawyer. You won't have to do much except answer questions and maybe sign a declaration. Now, the next phase is called mediation. And technically, the parties can schedule mediation at any point during the litigation process. But usually it's more productive after discovery and after any motions for summary judgment. A mediation is just a focused settlement discussion with a third party called a mediator. You will sit in one room with your lawyer, and the defendants will sit in another room with their lawyers and insurance representatives. The mediator is usually an experienced litigator or ex-judge, and they go between the two rooms, trying to nudge either side into a fair settlement. A lot of the time, if a case gets this far, this is where it settles. But not always. And if it doesn't settle here, then you're going to the final phase of litigation, the trial. Okay, so the final phase, and the thing we've all been waiting for, is the trial. And there is a lot that goes into a trial, so I'm not going to go over everything in this video. I'll make a separate video just about trial, so check back for that. But basically, during the trial, you'll be able to tell your story to 12 members of your community, and they will decide what a just outcome should be. The process starts with jury selection, and then opening statements, where your lawyer will give the jury an overview of what happened. Then we call witnesses to testify, which might include you, and both sides present all the evidence they have. And we finish with closing arguments. After all of that, the jurors will leave to deliberate and come back with their verdict. You might win and you might lose. At the end of the day, it'll be up to the jury. The trial process sometimes takes a few days and sometimes takes a few weeks. It will all depend on how complex your case is. So there you have it. Now you know exactly what to expect when you initiate a lawsuit against your employer. If you think you have a good case, make sure to reach out to an employment lawyer. If you live in Washington, feel free to reach out to my firm. The link to my website is in the description below. And be sure to like and subscribe to my YouTube channel. I make videos about the laws that protect workers. And the more we hold employers accountable for their wrongdoing, the more we protect other workers. Okay, that's all for me this week. See you next time.